For this topic, I'll be discussing criminal law, and I'm referring to Book 1 of your criminal law. So today, I'll be discussing the definition of criminal law, the definition of crime, the sources of Philippine criminal law, the principle of no common law crimes in the Philippines, as cited in U.S. versus Taylor, the power to define and punish crime, the limitation on the power of the Congress to enact penal legislation, okay, and further elaboration on the said limitation thereto, up to the principle on bill of attainder. So you will notice that criminal law is defined as that branch or division of law which define crimes, treats of their nature, and provide for this punishment. So you can remember this by simply having the keyword branch, crime, treats, punishment. So is that branch or division of law that define crime, treats of their nature, and provide for their punishment. So that's the definition of a criminal law. Now, there is a mention of the word crime in the definition. So which means that if criminal law talks about crime, then what is a crime? A crime is an act committed or omitted in violation of public law, forbidding or commanding it. Okay. Now, that is the definition of a crime, which is broad enough to include offenses and felony. Now, let's go to the sources of Philippine criminal law. The Revised Penal Code, Act number 3815 and its amendment is the first sources of Philippine criminal law or criminal law in the Philippines. The second sources is the special penal laws passed by the Philippine Commission, Philippine Assembly, Philippine Legislature, National Assembly, Batasang Pambansa, and the Congress of the Philippines. That's number 2. Number 3 is the Penal Presidential Decree issued during the martial law. So these are the 3 sources of Philippine criminal law. Now, we have this principle of no common law crimes in the Philippines. The so-called common law crimes in the common law crime, known in the United States and England as the body of principle, usage, and rules of action which do not rest for their authority upon any express or positive declaration of the will of the legislature, are not recognized in this country. Plain and simple. Because the Philippines, okay, is governed by law. Okay? All crimes that are defined and penalized under the Revised Penal Code, as well as special law, are enacted by the Congress. So if there is no law that was enacted and punishing that crime, then there is no crime committed. This is in consonant to the principle of nullum crimen, nullum pena sine lege. Moreover, as cited in the case of U.S. versus Taylor, there be a particular provision in the Penal Code special law that defines and punishes the act. Even if, okay, unless there is a provision in the revised penal code or under the special law, no matter how socially or morally wrong the act committed or omitted, the offender do not incur any criminal liability. As this is cited, I said, in the case of U.S. versus Taylor, an old case, but still controlling up to the present because of the principle of nolum crimen, nolum pena, sine lihe. Another question is, are court decision sources of criminal law? The answer is no. They are not sources of criminal law. Because court's decision are not sources of criminal law. Court decisions are not sources of criminal law because they merely explain the meaning and apply the law enacted by the Congress. Now, in that discussion, you will notice that the power, let's go to this principle, the power to define and punish crime. Of course, every state has the authority to punish, define and punish crime under its police power. And this is, okay, in the hands of the Congress, okay, to enact penal or special penal laws or to amend the revised penal code that we have. So in the case of People versus Santiago, the state has the authority under its police power to define and punish crime, to lay down the rules of criminal procedure. Okay? State, as a part of the police power, have a large measure of discretion in creating and defining criminal offenses.